The fragment comes from the beginning of session 3, which served as a practice of contrasting the positivist and natural law theories, with Hart and Fuller assumed as the main representatives, respectively. Lotte's comment comes from the opening discussion, when based on our understanding of the pre-class work readings, we form our initial understanding of how the learning outcomes of the class are going to be applied.
I think this really relates to distinctions definitions, and I felt that the authors were doing varying jobs at explaining what they were actually talking about. Actually, at some moment, I had quite a feeling that what one considered morals was something entirely different from what the other person was considered as morals, because Fuller actually had this place where he was saying that there's internal morality to law, which is created by somebody having to be disciplined in creating the law. But then I feel like being disciplined in creating the law is something so very, very far from saying that, as Hart was saying, the law, once it's created, has to be interpreted through a lens of ethics. So I actually agree with the confusion. And I guess I feel like that's what happens when we try to make really, really big claims about really, really big topics.
Lotte points to a really important definitional distinction between Hart and Fuller, that they seem to be talking about morality in very different ways. But what needs expansion is which concepts they specifically define differently, and why those definitions matter for their arguments about what law is. The distinction between them, in my understanding, is not that one simply cares about morality and the other does not, but that they define relationship between morality and legality in different ways, thus resulting in different outcomes when applied to society's behavior and legal proceedings. Hart's stance depends on a separation between law, defined as a social rule system, and morality, defined as a standard for evaluating it. His claim is not that morality is irrelevant, but that identifying something as law does not depend on whether it is morally good. He explicitly says that even morally evil rules can still be valid, that the existence of laws depends on the recognition of their source in encoded documents, not their moral worth. In his words, the validity of a given law is one thing, and the merit and demerit of the law is another. So Hart does not reject morality as an evaluative lens, but he does stress that we can condemn a law morally and still recognize it as a valid law. Fuller sees the morality's role differently. He introduces the idea of an internal morality of law. For him, laws must satisfy procedural conditions to even be laws. These include clarity, generality, promulgation, non-retroactivity, non-contradiction, possibility of compliance, constancy, and congruence. He refuses Hart's claims that the law's validity is solely based on its proper codification, and instead argues that if laws do not meet any of the 8 conditions, the citizens are not required to obey them, and justices are not obliged to judge with respect to them. His example of the incompetent monarch illustrates this well. A king who issues dogmas unpredictably, incoherently, arbitrarily, a ruler who constantly changes laws, issues decrees that contradict with each other, fails to clearly inform citizens of what rules must they follow. Thus, such dogmas, even if issued through authorized legal mechanisms, here by decrees of a ruling absolute monarch so accepted as valid laws by Hart, for Fuller are not law at all. His definition of law's legality, therefore, inherently includes a moral structure, because law must treat people as agents capable of following set rules. The difference appears even more clearly in the Spelunkian explorer scenario. One justice, Foster, mirrors Fuller's view. He argues that explorers trapped in a cave were no longer operating within the social conditions that make law meaningful, and thus the murder they committed was outside of a stable society, hence the statutes that prohibited did not apply. Thus, they must not be sentenced for murder. Another judge, Keene, takes a Hart-like approach. He states that the statute remained valid law regardless of the circumstances because the explorers committed murder in the cave that was within the territory of Newgart's jurisdiction, and since Newgart prohibits murder, they must be tried for it. Importantly, he does not reject morality. He stresses he understands the explorers' decisions, but he still advocates for the separation of those feelings, those moral dilemmas, from what is written in law. So the disagreement Lotte sensed is real, but the issue is more nuanced. Hart defines law so that morality evaluates it from the outside. Fuller defines law so that morality is at least partially or indirectly constituting it. And in practice, as showcased by the example, these definitional differences determine how each author explains what courts are obliged to base their verdicts on, and what rules the citizens ought to respect in their behavior. The fragment comes from session 4 on interpretativism, which was structured as a debate between pro-Sunstein and pro-Dworkin student teams. Shangda engages in the final rebuttal, and being on Dworkin's side, it directly presents ultimate arguments responding to the opposing team.
So I think that there are two main issues throughout this debate. The first one is that about the time whereby the other side, they were talking about how ethics might change and we'll just keep quote unquote inventing theories. So we have, I think, two responses to this. First of all, I think that contextual wise, we think that true, we agree that things changes and we will have like an immediate interpretation and address of the law as situation. But the issue is that at least for us, is that we have this law that we can fall back on. And although we also say that like we can build on the morality or like the judge can decide. And secondly, and the implication-wise is that we believe that justice delayed is basically justice denied. Because if you don't really solve the fundamental problems, as I think like Washington touched on just now, that something that needs to be resolved on the law level, you cannot just be making a law and then just ignoring like a marginalized group or whatsoever, because it doesn't solve the fundamental problem. The changes might, in this case, like changes, as they have mentioned, will be worse off on their side, because when people disagree on each other theoretically, then like it's going to be a worse off because there's no theory to back on. Right?
Shangda is right. The disagreement between Sunstein and Dworkin matters because it determines what happens when courts rule on socially divisive cases. Further, he is right in stressing that this has immense societal implications, especially when the rights of certain groups depend on whether courts wish to protect or restrain them, and when considering how justices holding such power are selected. Shangda's claim that justice delayed is justice denied is made in favor of Dworkin, and stresses the real implication of Sunstein's theory of incompletely theorized agreements, where courts decide narrowly and postpone deep disagreements so law can properly function without picking sides in society-wide moral conflicts. And the implication Shangda stresses is also accurate. When courts postpone defining what assertion of rights actually requires, unjust practices and discrimination can persist because no authoritative decision forces their protection. Legal practice shows this clearly. Courts reflecting Sunstein's framework often issue narrow rulings to preserve flexibility and to avoid controversial rulings. Sunstein calls this judicial minimalism. Justices resolve only what is necessary and leave broader contested principles unsettled to avoid tensions. And indeed, in practice, this can maintain legitimacy in the short term because varying groups can accept the narrow decision as upkeeping of a compromise. But it also means the foundational dispute remains unresolved, since no principle is set to precedent to guide later cases, only prolonging the purposeful obscurity. Dworkin emphasizes this. If law must be interpreted through coherent moral principles, avoiding those principles does not remove disagreement. It allows injustice to continue under the appearance of neutrality. The 2020 ruling of the Polish Constitutional Tribunal makes this clear. The tribunal de facto banned abortion access, grounding its reasoning in a strong, decisive interpretation of constitutional protection of life as encapsulating prenatal stages. The ruling immediately limited reproductive healthcare access nationwide, showing how influential setting a concrete interpretation rather than waiting for the societal consensus to form can be. Disregarding whether the polity agreed with the outcome, this illustrates Dworkin's implication that once court defines a principle, the consequences are systematic, unavoidable, and uniform. But the same case also shows the risk Sunstein identifies and Shangda omitted. When courts settle moral disputes at the principle level, they may substitute democratic deliberation with a small group of persons in power, imposing their interpretation on a larger society. In this case, 9 justices, 7 of them male and 2 of them previous members of the then ruling conservative coalition, banned abortion nationwide. Their position allowed them to encode their widely expressed personal beliefs for a constitutional interpretation that overrode social disagreement, effectively putting women in danger and refuting a major part of their reproductive rights. If Sunstein's framework were employed, a narrower ruling might have preserved legitimacy, reflecting democratic ideals better by keeping the matter open rather than encoding the beliefs of 8 politically selected justices. So Shangda's point stands. Dworkin's framework, which prioritizes decisive resolution of rights, if applied, indeed leads to effective enforcement of a uniform interpretation. But the analysis of implications is incomplete without stressing Shangda's assumption that the imposition of such leads to a just outcome. The Polish example shows that codification of a strong belief can result in an unjust law if the positions of power do not reflect societal disagreement, thereby decreasing democratic contestation. In reality, regardless of whether courts stabilize society through compromise per Sunstein or remake it for principle per Dworkin, both can hold social consequences, especially for underrepresented groups. Hillary comments on Kaufman and Runnels, the core of an unqualified case for judicial review, a reply to Jeremy Waldron and contemporary critics. Commented upon parties from page 165. Quote, according to Waldron, these issues are too substantial and controversial to be removed from the jurisdiction of democratic politics. Hillary, I think this part raises a very fundamental question about what makes political decisions legitimate. Waldron seems to think legitimacy comes from the process itself. People must have a say in resolving disagreements about rights even if the outcome isn't perfect. I'm trying to figure out whether he is implying that participation is more important than correctness. It almost feels like he believes that being treated as an equal decision maker matters more than whether the right decision is reached, which makes judicial review problematic from his perspective because it removes certain decisions from collective democratic control. Hillary's comment stresses a legitimacy criterion, deciding if a political decision counts as legitimate because everyone affected had an equal chance to participate in making it, even when the outcome is wrong. And further, if so, if judicial review is democratically destructive, as it shifts authority to decide about rights away from bodies elected by the populace. In the part commented upon, Waldron's claim concerns where legal authority to settle rights disagreements should lie in a democracy. He argues courts cannot legitimately assert constitutional authority to strike down legislation enacted by an elected legislature on the grounds that it violates rights. Instead, only elected representatives of the polity can legitimately resolve disagreements regarding the nature and extent of such cases. The passage grounds this in democracy's most fundamental commitment, the imperative that each person be treated as an equal in collective decision-making, applied to intractable, controversial, and profound questions about rights. On this view, equality in participation is what generates legal authority. When citizens disagree about rights, the only institution that can claim legitimate power are those that reflect equal political status. Judicial review becomes problematic, per Hillary, because it reallocated the final say from such bodies to what Waldron describes as an unelected and unaccountable institution, and equality is therefore lost from a democratic point of view. In this sense, constitutionalist defenses of judicial review fail to sufficiently account for the right to have one's own voice counted in resolving disputes over the meaning and extent of right. That's because judicial review shifts who gets the final say from a procedure that treats citizens as equal to a procedure that does not, undermining, not strengthening democratic governance. Hillary's concern is clear when constructed with the opposing view Waldron rejects. For Dworkin, the authority to decide rights should come from the requirement that law must be interpreted in a way that best supports the community's moral duties. Courts are tasked with enunciating what citizens are entitled to based on provisions, and thus, judicial review protects especially minorities because it ensures that majority does not seek, and especially succeeds, at taking away their rights through proportionate representation. And this is where Waldron draws the line. He does not reject that rights have a moral value or that courts ought to protect them, but he denies that such correctness should substitute equal political status in answering contested questions. If citizens disagree about what rights require, giving final authority to judges extends beyond the court's duty to assess interpretation and instead gives them the power of equal authorship to the elected legislature. Roe v. Wade demonstrates this. In 1973, the US Supreme Court's ruling set a minimum constitutional baseline, placing it beyond the legislative authority to deprive women of their rights to abortion and access care. From a Dworkinian perspective, this is an example of courts exercising legitimate authority because justices assess the scope of constitutional rights regardless of a majoritarian opinion. From a Waldronian perspective, the decision is an example of democratic undermining, as a small group of politically appointed judges assessed a contested moral question for the entire populace. Thus, Waldron's take is procedural. Authority comes from inclusion in the decision process. Dworkin's is interpretive. Authority comes from the principled rationale of outcomes. And while they both agree that courts have a duty to protect rights, depending on the adopted theory, judicial review either appears as a safeguard or as displacement of democracy. Tuong comments on Circus's Civilization, the Civil Code, and Child Marriage in Sex, Law and Sovereignty in French Algeria, 1830-1930. Commented upon parties from page 91. Quote, By recognizing Khadija's marital desire, the court effectively linked the women's marital consent to their acceptance of the Court d'Alger's jurisdiction. Women's marital desire thus worked to legitimate the French court's oversight of Muslim law. Tuong. This claim is confusing. How can women's consent, which seems pretty empowering, also legitimate colonial control? I think Circus is arguing that consent functions ambivalently. On one hand, women who appealed to French courts gained a limited form of legal agency. But on the other hand, the court recognized that agency only when it aligned with French legal norms. In this way, women's expressions of consent or refusal became evidence that French law was morally superior and necessary, which means agency was channeled into reinforcing colonial legal authority. Tuong's confusion comes from a background assumption structuring the entire passage. Colonial justices treated French law as the civilizational and normative baseline, while Muslim law was framed as deficient and in need of correction. French law was assumed to embody morality and universal justice. Indigenous practices were seen as disorderly, patriarchal, and backward. The assumption was explicit in how intervention was justified. Purple Pete refusing reform of indigenous law would mean deserting the cause of civilization that we represent in this country, presenting reform as a moral obligation. Once that assumption is identified, the ambivalence Tuong notes is clear. Circus stresses that marital consent trials made women's agency function as an expression and extension of marital desire, but also tied that desire to the legitimacy of French law. In easy terms, French courts interpreted women's consent as both evidence of individual agency and as confirmation of the need for French jurisdiction. Consent was therefore not treated as a universal principle, but a practice legible only within the French oversight. The same assumption explains how Muslim laws were characterized in moralized ways. The droit de gerbe, a customary Islamic law in Algeria allowing a paternal guardian to enter his daughter into a marriage without explicit consent, was described as contrary to morality and to human liberty. Regardless of this claim's soundness, this does more than condemn the practice. It frames the legal culture producing it as uncivilized and therefore in need of reform. Further, the French retained the right to abolish a law or custom which is contrary to public's order and social interest. The introduction of one reform is thus taken to show the imposition of French customs as a principled, not political, civilizing process. The codification of consent is not aimed at empowering women, at protecting them from patriarchal abuse. It is used as a tool to legitimize colonial rule, as bringing justice overall. The change of one rule was thus used as an example that French authority as a whole was civilizing the Muslim world, which was assumed to be entirely barbarous. Therefore, Tuong is right to sense a contradiction, because the contradiction is precisely how colonial legal authority operated. Women's consent appeared empowering because it granted legal standing absent under customary law. But for the French, it functioned primarily as evidence that their law is normatively required and morally superior. Agency was acknowledged, but only in a form that reinforms the colonial French law as a universal baseline of justice. In essence, the French relied on a classic flawed argumentation, that the part constitutes the whole.